Good morning, friends. Sat Sri Akal, Adab. I would share the word called old grant. What does old grant mean? Today, I'll be covering some various books which came in my hand during research and what these books actually speak of. Are these old grants royal grants? Are they Badshahi grants? Or they are non-Badshahi grants under the regulation 36 of 1803. This is even mentioned in the Punjab land manual that when Mr. Barkley was making an assignment of Delhi territory, where a limitation was imposed by the terms of grant either upon the succession or upon the right to transfer the tenure. This of course does not apply and the Punjab rules are applicable to the fullest extent to grants made after 1857. Now this statement of the case requires some amplification and correction which Mr. Barkley had said in this book. Now what does it mean? So whether these were grants given prior to 1857, the mutiny, or 1803 when the Britishers actually started putting their foot on this area, I'm talking of the Punjab. No, we really need to specify what these grants are. So let's read these regulation 31 and 36 of 1803. Now this of 31 of 1803 declared what grants other than royal or Badshahi grants should be considered valid in the ceded provinces. Now ceded provinces were those provinces which were taken up by the Britishers. Now this is where the ministry says by war, and provided for their registration and for adjudication upon them in the court of law. Now when the area got ceded, so that grant which was lying there of the ruler or of the royal grant or the Badshahi grant was subjected to the court of law. Now similarly, regulation 1336 of 1803 enactment said the similar provision for royal grants. All grants as major to the place were put under this. What is it saying? Somewhere, these assignments of these old grants were named like this. Assignments were confirmed under these regulations which I just mentioned of 1803, regarded as private properties, and therefore these private grants were transferable. Now here came the theory of nature that these were revenue free tenures, were classed as hereditary grants. Now, weaver grants, if you even today say a grant is transferable or heritable, it goes from father to son. Now, whether the government says give us an admission deed, write this, that is segregated. We are just talking of these old grants, and such grants are in perpetuity for life. Hereditary grants were transferable by gift, sale or otherwise, but in the revenue for life of the grantee. It is needless to describe what under these regulations were declared enough to be sufficient, that grounds were being accepted as land revenue free. So Barkley was very clear in his assignments in Punjab that these grants were acceptable. So old grant was defined. Now similarly, in the same section 2 of 1875, the settlement officer mentioned that these grants were supposed to be royal grants. Even it came down in a book called Ambala Gazetteer of 1882 that revenue free grants were known as Charmari grants. Now these were those grants which were originally in the hands of the Jagirdars, the original rulers, and various communities down the line were given these grants. So where were these settlements being taken place? And I'm talking of Ambala because I have this gazette here. It very clearly restricted in some areas that whether these landowners would be called proprietors or not. So now was the British settlement at that time looking for these old grant people who were revenue free or heritable grants? Were they to be given proprietary rights in their lands? So these attempts were being made, somewhere. How to diminish these grants, which were revenue free grants. How the Britishers were playing, they were trying to, defray the rights of these original grantees. So the officer who affected the settlements of the southern portion of the district of Ambala was an advocate for their recognition, either by actually making the settlements with them as proprietors, or where there was not possible, by assigning them an allowance under the denomination of the Biswadaris. This is very important. See, the government of that time, the British were only looking for a lagan or for a non-revenue free grant. So Mr. Barkley, in his report, laid claim both for the right to engage for the revenue and for the right to collect. The Biswadari allowance was subjected. Such cases were mostly settled by arbitration, but no doubt the basis of settlement officer contributed in certain degree to enhance the number of those who obtained recognition of antiquated rights. Now, what is these antiquated rights? These are those old grant rights. The officer who conducted the settlements of the Northern Tehsil, on the other hand, was of the opinion that in the majority of cases, the superior rights of such original proprietors had fallen too completely into abeyance to admit of their recognition, and his policy was to maintain as proprietors of all those who were found in proprietary possession. So he was granting an extra Biswadari allowance to those original proprietors or original old grantees. So friends, this is how things were changing, in 1803, and these old grants of revenue were being. So now I'll read a chapter where Chahdrami grants were specified. Among the complication arising from the Sikh conquest in the district, most of the peculiar grants or the tenure of the Chahdramis, what was the share revenue which was being given? That was just 1/4. The tenure had its origin in a common custom of the Sidh Satluj Sikhs, which was struggling for possession of particular tract, either by themselves or among themselves, or by opposition, or by an original old grantee of the ruler. So this kind of a compromise was being taken place in these settlements when they were happening. So the produce or 1/4 of the tract was being recognized to the smallest tiller, that was the Chahdrami. So we need to understand that the British were only looking for converting these old grants, which were revenue free grants, into some kind of lagan or some kind of produce to be paid back to the, either to the Jagirdar in a format or to the British government. So that was 1/4 of the produce. Both contending parties, in other words, became Chahdramis, and they were holders of that 1/4 of the produce to be paid to the British government. So who was the one who was weaker or who was above the other one? It again became a question of debate. So in gradual time, or in technical words, the division was taken into half portion as a revenue, because 1/4 meant half. The other two were lying with the original grantee. So there was a dispute which was taking place in these old grants. So now came that these Charmari grants were put subjected to the Jagirdar or to the Talukdaris. Otherwise they could not have happened. Now Britishers were trying to recognize these original Charmaris who were the tillers. Ki, okay, you pay us 1/4, we give you the rights of revenue. Now what was the revenue? Which was originally in the hands of the Jagirdar, and it was a revenue free grant. There was a clash. Now here we will talk of the bungalow area or the bungalow owners who were actually the Talukdaris or the Charmaris or the Jagirdaris. So this class was basically extinct. So, these revenue free grants and the Charmaris or the 1/4. So somewhere this was all getting too much cobwebbed. So the land revenue officer or the settlement officer was either assigning it to A, that is the Charmari, or was actually looking for the Jagirdar who was originally the revenue free grant. So settlements were to be taken place. When the time of settlements arrived, great difficulties were experienced in dealing such cases. The chiefs themselves became mere Jagirdar, and while the government determined to continue the allowance to the Charmari, it was considered at the same time inexpedient to look upon them as shares in the Jagirdars. Some of the Charmaris were proprietors in actual who were cultivating as well as were in possession, while others on the other hand belonged to a class which already existed called the Talukdars. In both cases, the Charmari allowance was completely separated from the Jagir. If the Charmari was recorded proprietor, his revenue was reduced by one half. If on the other hand the settlement officer decreed him on the position of the Talukdar, then the settlement was made as the usual rate with the proprietor, and the Talukdar was declared entitled to receive a rent charge equivalent to 1/2 of the revenue assessed. So the remaining was going to the government or to its assignee, the Jagirdar, as in the case might be. So again the government was putting itself into a problem. So this cobweb was not being very clearly defined. So old grants were mainly revenue free grants which were in the original hands of the Jagirdars, subjected to alienations of Talukdar, Biswadar, Charmaris or Musuridars. These were different names given to different statures of the tillers. So the assignments of revenue which is written in the Ambala Gazetteer as well as which is defined in the CLA rules rule 4 of 1937 and the government grant acts of the written in the book of land and landlords of tenants, it clearly said land revenue receipts are peculiar oriental in origin, namely that due to the practice of assigning or alienation to individual the rights of government to collect its demand from the land or of permitting individuals to hold their land wholly or partially revenue free. Ambala province was taken over from the preceding native ruler and an immense number of such grants were found in existence and an immense amount of time was spent in the early days of British rule in determining to what extent and on what terms such grant would continue. So this new grant chapter still sometimes makes a lot of difference and was there, but the majority of those now in existence are those grants which were inheritable and from the native ruler directly called old grants. So friends, we need to understand this. So this new grant of this chapter really speaks of the inheritance from the native ruler. And these grants were those grants which were in form of some kind of services to the then ruler of the government, or a community service which was intangible, and it was very oriental, which is called ancient. So these grants had to be recognized, and they were called old grants. The term settlement could never take place in Punjab for this very reason, but it never came to Punjab into use, where the greater part of the province in the shorter terms was considered on a possessory holding of 20 years, which later increased to 30 years. So the usual term could not be defined in Punjab, that who would be the settler. So let's say if 30 years or 20 years was the condition, from 1765 or 1795 or 1843, when let's say Ambala became a part of the British regime, these are questions which really need to be defined. So friends, please understand my videos and let's meet together. Let's get together. Thank you. Good day. Namaskar.